and in essence, based on the record before us, it is evident that PSC failed in its mandate. The undeniable conclusion is that the process of establishing the extra 27 posts was unconstitutional.
I'll go straight to the next issue.
Any of the issues raised judicata. 3. Was there adequate public participation in the creation of the office of CAS and in the appointment of the CASs? 4. Did the President and the PSC have the power to create the present office of CAS in the manner in which it was created? 5. What are the financial implications of the creation of the office of CAS, and is it a waste of public funds contrary to Article 10 of the Constitution? 6. Was the President improperly enjoined as a party to the consolidated petition? 7. Who should pay the costs? We have also found that the following supplementary issues call for our determination. 1. What is the constitutionality of Section 26(2) of the SRC Act and the regulations thereof? 2. Was the first interested party improperly joined as a party to the consolidated petition? 3. Was the consolidated petition drawn with sufficient precision? And 4. Should the court consider matters that were not properly pleaded? The first issue, does the High Court have jurisdiction? We have considered the written submissions of counsel, as summarized above, together with the numerous authorities cited in support of the said preliminary objections, including Nick Kithinji Institute versus Clerk of Kiambu Assembly, and several others. I will not recite them all. Having carefully considered the above authorities and the submissions of counsel, in particular the argument that the ELRC has unique competencies in the areas of employment and labor relations law, and that this court ought to defer to it on that basis, respectfully we find otherwise. We are guided by the decision of the Supreme Court of Kenya in Samuel Kamara Sharia, Supra, where the Supreme Court held as follows. A court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. The jurisdiction of this court flows from the Constitution of Kenya. Article 165(3)(b) of the Constitution reads as follows, and I will not read out the entire clause because I know we are all familiar with it, but I will move forward and say that based on the law as set out above, and looking at the various issues raised in the consolidated petition, we are of the view that our mandate has been properly invoked. In particular, the consolidated petition raises numerous and weighty constitutional issues that go beyond employer and employee issues. The primary or core issues before this court are in fact constitutional in nature and call upon this court to interpret the Constitution as a whole in order to reach its conclusions in relation to the issues and relief sought. This exercise falls squarely within the confines of Article 165(3)(b) as set out above, and we find that this court is accordingly properly seized of jurisdiction. Based on our reasons as set out above, we find that the preliminary objections dated 21st and 31st of March 2023 are without merit and the same are dismissed. The next issue. Are any of the issues raised in the consolidated petition res judicata? The first to the fourth petitioner sought the following consolidated reliefs in the consolidated petition. I will not read them all out, but our decision has summarized them all. I will go straight to the next part after that. Moving forward, all the parties prayed for costs, and the first to fourth petitioners prayed for any further reliefs that this court may deem fit. Having set out the issues in various reliefs sought by the petitioners above, this court and all the parties are well aware that the present dispute has been the subject of litigation in two previous matters over much of the same subject matter, namely in Okia Umtata and another versus PSC and 73 others, and LSK versus the PSC and others in the Employment and Labor Relations Court. A reading of the above decisions by the High Court and the ELRC reveals that each court heard and determined the matters conclusively and reached various conclusions in relation to numerous issues that are presently before this court. Accordingly, several of the petitioners, respondents, and interested parties rightly submitted that those issues determined by the said courts are accordingly res judicata. We are of the view that res judicata applies to a number of issues in the President's consolidated petition, which have been litigated at length and determined, albeit involving different parties to the present consolidated petition. We do, however, note that LSK was the petitioner in petition number E.74 of 2022 and in the Employment Labor Relations Court, and was also an interested party in the Okia decision.
The PSC have the power to create the current office of CAS in the manner in which it was created. The consolidated petition requires us to interpret a number of articles in the Constitution. We are well guided by Article 259, which provides as follows, and I shall not read it. The principle